Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague Russell Berger from the Offit Kurman Labor and Employment Groups. And today we are going to be talking about a ban on arbitration for sexual assault and sexual harassment that has recently passed through Congress and is awaiting Biden's signature as we're recording this. We do think that Biden is going to sign the bill, so this is something that employers are definitely going to have to keep an eye on, and may change some of the agreements that they currently have in place with their employees. What are we looking at with this, Russell?
Yeah, so the gist of this is, and this is really, an outgrowth of the Me Too movement, and ostensibly, employers that have mandatory arbitration clauses with their employees are not going to be able to enforce those arbitration clauses as it pertains to sexual harassment, sexual assault type claims. Now, there's to be determined where sexual harassment, sexual assault stops and other types of claims begin and what gets lumped in with it. And there's probably a lot of practical issues that are still going to come on that. But that's the simple version of it is that sexual harassment claims, employees that have those claims are not going to be held to be required to arbitrate them. They're going to be able to litigate those in court. And a couple other points on it is if there's a dispute as to whether this revised version of the Federal Arbitration Act applies to a specific claim or not, a court will decide that issue, not an arbitrator, and it will apply to claims prospectively, even if the misconduct is in the past. So, for example, if there was harassment that took place in January and this law gets signed into law this month, and then there's a lawsuit filed in March or April, the employee is going to benefit from the protections of this law and be able to file in court.
Yeah, so this will definitely change because a lot of my clients will have arbitration agreements in their employment agreements. And so this is definitely something that employers will have to take a look at and see, do their contracts contain these provisions? Do they need to carve these out? And definitely go back to the drawing board there. I think just generally too, arbitration is one of those things that is not always well understood. I think we maybe have talked about it on OK at Work before, but arbitration is definitely something that you don't want to just always include necessarily. You want to be thoughtful in your approach, and this I think even supports that even further, right? So this is just another thing to have to keep in mind when choosing arbitration. But arbitration can come with a lot of expense and things like that. So I think this is a good time to really think about, well, what's in my contracts? Do I really want it there? And what makes the most sense? So something to revisit, and we'll definitely be keeping an eye out on whether Biden signs the bill and what comes from it.
Yeah, yeah. Well, I don't think it's so much a question of if he signs it, it's more so when he signs it and when this goes into effect. Yeah, I agree. I mean, I know we've talked about arbitration clauses, and I think I'm sure I've said I'm not the biggest fan of arbitration clauses. I think there's a time and a place and a proper use for them. And it has to do with avoiding the risk of class actions for the most part. But it's another reason to just think about your arbitration clause in general, or your form selection clause in an employment agreement or a restrictive covenant agreement in general, and figure out what it is that you really care about. Because maybe your concern is not so much the confidential nature of arbitration, but maybe you just want to avoid a jury. Well, you could be in court and you could avoid a jury. If you have an arbitration clause that's not enforceable, that's not going to help you avoid a jury. But if you have a language that says, we're going to go to court, but we agree to waive jury trial rights, then that is going to help you and be enforceable. So it's just another reason, another inflection point to look at kind of what you're doing holistically overall, and consider whether you ought to make any changes to what you're doing now.
Yeah, be purposeful about those choices, because a judge is that you don't have to worry about those paying those arbitration fees for them. So, well,
That's
thank
right.
you, Russell, and we'll see you next time.
Thanks, Sarah.